together. Believe me, people, when I say the pieces we've been trying to find will turn up if we could only get our heads together. Nobody is gonna get this ship right for us people. Nobody is gonna get this ship right for us people. Believe me, people, when I say there's no more to be said, all we can do is to be. That's the question. To be or not to be is not the question, but to be is much more sweeter, and that could be the answer. Nobody is gonna get this ship right for us people. Nobody's gonna get this ship right for us people. We got to make it. 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 Yeah, we got to make it. We got to make it. I said we got to make it. 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 I said we got to make it. We got to make it. Tra la 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 la. Tra la la, that's all I can say. Tra la 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 la. Tra la la, that's all I can say. Tra la 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 la. Tra la la, that's all I can say. Tra la 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 la. Tra la la, that's all I can say.
Welcome, and thank you for accepting the invitation to join community events hosted by the Solidarity Building Initiative at McCormick Theological Seminary. I'm Avalon Betts-Gaston, an SBI Community Advisor. As an advisor, I support the SBI mission and vision to mitigate material, social, and political barriers that system impacted individuals and their communities experience while incarcerated and upon release. I am a woman whose faith is at the heart of my deep desire to dismantle, change, and build a true criminal justice system. So, yes, I am an abolitionist, and it is because of my faith. It is indeed my honor to be a part of this presenting this teach-in today.
And I'm Jia Johnson, the Program Director for the Solidarity Building Initiative. The program offers a certificate in theological studies to individuals who are detained at the Cook County Department of Corrections. In addition, we also host community events to raise consciousness on issues of mass incarceration as well as to build communities of advocacy and reentry support. And I do have to give a bit of a shout out to Avalon. We are super grateful to have her as an SBI advisor. She actually suggested this teach-in. She's also the one who connected us with the National Council for Incarcerated and Formerly Incarcerated Women and Girls. And her experience as a lawyer has been vital to helping us plan this event. So thank you, Avalon. Over the past 3 months, SBI has hosted a series of events focused on healing and equipping participants with knowledge and practices to become community healers committed to creating beloved community. And so today's teach-in is the culminating event of our 3-month journey on healing and equipping. Today's teach-in is, and so SBI teach-ins are intended to activate our political consciousness and exercise our civic engagement on issues that create a better world for people and communities impacted by our criminal legal system. And so you might be asking yourself, how does a teach-in on jury nullification connect with our theme, healing and equipping?
So our current criminal legal system is not designed to provide restoration, accountability, or healing when harms have been committed, which are all the things necessary for justice. Our current system is intended to punish, and Black, brown, poor folks, women, and transgender are disproportionately impacted by the retributive practices. Too often, people are criminalized and incarcerated for engaging in survival activities that have been deemed criminal by the state. People working in the informal economy need access to jobs, not incarceration. People with mental health and chemical dependency need treatment and healthcare, not incarceration. And let's not forget that women simply trying to live to see another day or desperately trying to care for their children need care, not cages. Today, we have a choice. We can continue to try to punish our way towards harm reduction, or we can actually reduce harm.
And so the power that a juror has to return a not guilty verdict, even though jurors believe beyond a reasonable doubt that the defendant has broken the law, has the healing power to change the life of not only the defendant, but also their family and society. We might even consider that jury nullification is is a politic of resistance in response to draconian laws and sentencing practices. Plainly, the juror has the power to save lives, and a consistent pattern of acquittals for prosecutions of a certain offense has the potential to influence the amending of laws.
Can we present the slides again? We have been working over the last several weeks with a team of dynamic and brilliant humans to host an interactive and informative teach-in that includes conversations with faith leaders on justice, conscience, and juries. Our panelists will discuss some concerns you as prospective jurors might have about the ethics or morality of participating on a jury, even if you are confident that what you are doing is legal. We are excited for you to meet our team of lawyers, activists, and clergy. You are in for a treat today.
Indeed, you all are. And so before we get started with our training, we have a few housekeeping items. So in this age of Zoom fatigue, we want you all to please prioritize your well-being. As you've already seen, we'll have about 3 breaks, and they're fairly long breaks, but feel free to please come and go as you need to take care of yourself. We will be here until 1 o'clock. The training will also be recorded, and we'll be able to share that out later as well. We will be monitoring the Q&A, so please feel free to submit your questions there. If there are questions that we are not able to get to, we will follow up with some answers in our post email. And so just again, thank you for spending your Saturday morning with us and taking the time to learn about this important tool that we have available to us. And now I'm going to turn it over to Reverend Naomi Washington Leapheart, a professor of theology and religion at Villanova.
Thank you, Jia, and thank you, Avalon. Good morning, everyone. It is my honor and my joy to be here with you. I just wanted to offer a couple of reflective remarks as we begin this conversation about how to know our power as jurors. I want to begin by telling you a story. Once upon a time, there was a young man named Jay. Jay was used to being tolerated. You know, he was tolerated in his family. He grew up in a house with brothers from another mother, literally. They called him illegitimate. His father didn't protect him from the cruelty of his brothers when his father was alive. And when his father died, Jay's brothers denied to him what was rightfully his, a portion of the inheritance they were all due. So Jay grew up and left home and went to live in another city, and he found family there in the streets of that city. He found family among other sons who had also fled the brutality of their home situations. Jay's crew had had enough of being robbed of their dignity and their pride, and so they decided they would become the thieves. Jay built a reputation as the leader of this crew. He built a reputation as a mighty warrior, and word got out. Word spread about Jay. Word about Jay got all the way back to his hometown. And the rumor mill, always seems to have convenient timing. Joe's home city had just entered a war with another nation, right about the time they found out about Jay's reputation. And so the leaders of the city, who happened to be Jay's brothers from another mother, said, listen, we need to recruit some good soldiers who can help us win this war. I hear that Jay has become a mighty warrior. And so they went to visit Jay, and they tried to entice Jay by inviting him to be the commander of the national army. They said, we hear that you're the best. Come and fight for your hometown now. Jay, of course, was rightly suspicious. He said, are you not the very ones who rejected me when I was younger? Aren't you the ones who drove me out of my household? Aren't you the ones who shamed me, humiliated me, abused me? And now you come to me when you're in trouble? The city leaders said to Jay, well, that's water under the bridge. Let's let bygones be bygones. We are now turning back to you. Now we invite you to be in charge. And so Jay said to them, okay, if I do this, if I come back home with you and I lead this fight on your behalf and we win, I want to be your boss. You need to make me the leader of this city. So the city leaders, they didn't take long to deliberate. They vowed to Jay, the Lord is our witness. You have our word and our promise. You will take charge over us. Jay, after this negotiation, this deal making, decides to continue in this negotiation. He contacts the other nation. He introduces himself as the general of the army, and he says, what beef do you have with my people? And that other nation replied, well, y'all are some thieves. When your people were generations ago trying to survey options for where you would settle, you took our land. Now it's time for you to give it back peacefully. Jay said, no, we didn't steal your land. We encountered your people as we searched for a place to go, and we asked your leaders permission to pass through here on the way somewhere else, and your leaders said no. And your leaders launched a preemptive strike against us. But guess what? We won that battle all those years ago. And after we won the battle, well, to the victors go the spoils. We moved right in. And furthermore, we believe that God gave us this verdict. You started it and God finished it. Are you going to argue with God? Shouldn't we not claim everything that God has given us? Jay goes on to say, and anyway, why did it take you so long to lodge this complaint against us? Why didn't you fight this fight a long time ago? Jay boldly then ends the conversation with this: God decided for us then, and God will decide for us today. Well, the leaders of the other nation, they didn't back down. There would be no compromise, no middle ground, no agreeing to disagree. This made Jay even angrier. Whatever reservations he had had about fighting for the people who had betrayed him, they were gone. His pride was wounded now, and so he gathered his troops and they proceeded to the battleground. Now remember that Jay is always the deal maker, always the negotiator, and so on the way to the battleground, Jay says a prayer. God, if you give this war to me, if you give me this victory, then whoever comes out of the doors of my house to meet me when I come home after winning this fight, I will offer up to you as a burnt offering. Jay opens his eyes after this prayer, crosses the line of scrimmage, and fights his enemy's enemy. And he wins. He inflicts a massive defeat. He leaves no area unscorched. He utterly subdues the other nation. Weary and perhaps wounded, and I'm sure relieved, Jay comes home. And as he approaches the house, he sees his daughter, his only child, his baby girl, coming out of the door to meet him with music and with dancing. I can hear her now saying, "Daddy, you won. Let's celebrate." Can you feel her joy? And can you feel Jay's dread? When he saw his daughter, he was so agonized that he tore his clothes off his body and began to weep. He said to her, "I made a vow to God and I can't take it back." She was devastated. But she said to her father, "If you made a vow, then you got to keep it." So after a period of mourning with her friends, Jay's daughter laid down on the altar and surrendered herself. And Jay kept this terrible, terrible vow and lost his only child. This story is plucked from the ancient text of my faith tradition, the Bible. Jay is Jephthah in the biblical story, and Jephthah is a desperate man who makes a desperate vow to prove once and for all that he is valuable. He is legitimate. He is a patriot. Jephthah wants to use this opportunity to spite the system that had rejected him. He wants to be the one with the power to determine who lives and who dies. And he seals this plan with a terrible vow. He makes a promise that actually functions to uphold the systems that have caused him harm. He is lured by his shame, by his desire for redemption, by his claim of respectability. He is lured to participate in the very violence that has hardened his heart, in the violence that has alienated him. Lest we think this is an old story about an old phenomenon, I want to suggest this morning that Jephthah's tragedy could have been plucked from the sacred text of our own lives today. In a political context where negotiations are a zero-sum game and people are sacrificed every day in the name of law, order, and protocol, vows are dangerous business today. In a society where judges are proxies for God, where what is legal is not always what is moral or ethical, and where sometimes truth and candor are punishable offenses, vows are dangerous business. So I'm here today because of the ways that oaths have been used to silence critique, objection. I'm here in theological subversion to the idea that God would ever consent to a deal that ends life. I'm here to speak out against any legal tradition or obligation that baptizes the apparatus of state violence, whether in the form of never-ending punishments or verdicts of lifelong shame. So I just have a couple of questions for us to consider as we go into this moment of education. What if we saw breaking vows as tools of community healing? What if we committed to breaking promises that terrorize other members of our community? What if we believe that we have a duty to actually abolish traditions that force us into violating our own minds and hearts and values? What if we embrace the idea that serving on a jury is not about deciding who gets to live, who gets to die, both literally and figuratively die, but is always about determining how we can better live together, how we can hold ourselves accountable and repair harm while preserving life and dignity? What if we stopped asking people to support misguided jurisprudence in God's name? I'm so glad that we're here today together to exercise our power to resist, as Jia has said. Resist by faith, resist by conscience. And I think that conscientious acquittal is not only our legal right, but it is our holy mandate. And so I'm looking forward to talking more with you all today and learning in this moment of political resistance and education. Thank you so much. And I want to turn us over now to a video. I encourage you to give your attention to the video that will now play.
To the members of the jury that get to decide my future, it has been so hard to sit here and listen to the prosecutors, complete strangers, tell you about the person that I am. The person they believe me to be is not the person that I truly am. A moment in my life, a bad decision even, does not define my being. I am a mommy. I have 2 children, 2 beautiful children. My daughter Jordan and my son Logan are my whole heart. Being arrested does not erase my love for them. Sitting in the county jail year after year awaiting trial does not make me forget about them. They are my first and last thoughts of the day. The worst of prison sentences could never inflict more pain than I feel for not being there. I am a daughter and a sister and an aunt and a friend to many. Sitting in this courtroom awaiting judgment lessens that none. What I am is an addict, a word that I never thought I would be. I never had any experience with drugs, so an addict I never thought I could be. As a little girl with severe asthma, I was treated with steroids which attacked the bones. This unknown when I was that little girl. Would I still have taken the medication? Absolutely. If I cannot breathe, I would not need bones anyway, for no real reason. And with bones that fought against fusing back together, I was kept not only in a cast on my wrist and foot for 6 months, but I was kept on pain pills. Nothing super powerful, but enough to take away the pain and enough to become addicted. Fast forward 6 months and my orthopedic surgeon sends me to a pain management doctor so that I do not become addicted. Far too late for that precaution. In my addiction, I still worked. I still paid bills and as a single mom raised my 2 children. I continued taking the pain pills because my body could not function if I didn't. Oh, how I wanted to stop taking them, but my lethargic body isn't ideal for a single mommy with a job. I'm not making excuses. This is simply my truth, my life, my story. There are no programs inside the Department of Corrections that will help me with my addiction. I really just needed to be forced to endure detox, which I have done. I no longer feel an overwhelming desire to use drugs. I just wasn't able to stop. It is far easier to stay sober than it is to get sober. To send me to prison will cause a level of harm to my son and my daughter that have done nothing wrong. A family bond that was once strong will be broken. Time and separation will do that. What little boy or little girl doesn't need their mommy? My community, your community, will have to pitch in to help raise this little boy and girl. Taxpayers will help put food on the table and provide medical care, as this is an unplanned expense. If you send me to prison, where will I go upon my release? Taxpayers are not going to want to foot the bill for me. There is no monetary value that can be placed on the damage that will be forever inflicted on every single member of my family. Because of a mistake I made. A mistake, a moment that will destroy life as so many know it. I just needed help. That's all. I just needed help. I do not need to be sent to prison where I will play witness to an unending level of physical, sexual, and mental abuse. I need to remain in my community where I can raise my children, be a productive member of society, and educate others through the experience so that they do not too make the same mistakes I did. There is so much color to me to contrast the black and white the prosecutors have mentioned. And I do not deserve to be thrown away. I do not deserve to be given up on. No one does. Deborah Bennett Austin.
I'm on mute. Okay, you're good. Am I good? Yes. Okay, I apologize for that. My name is Catherine Sevcenko. I am the senior counsel for the National Council for Incarcerated and Formerly Incarcerated Women and Girls, also known as the Council to the Council. I am joined today, or my partner today is Kirsten Tynan from the Fully Informed Jury Association. And we are going to be laying out the basics of conscientious acquittal, also known as jury nullification. And some of this is going to be somewhat technical. It's always dangerous when you get lawyers involved, but I ask you just to bear with us because this information is important. And just think of the video you've just seen, Deborah Bennett, because the information you will hear now will help you help the Deborah Bennetts of this world when we get to the other side. So if I could get the next slide. So this is, I think, an arid and legalistic way of saying some of the things that Reverend Naomi was pointing out, and in terms of what I hope that we'll be doing today, to really enrich the idea of what an oath is and what people's role it truly is as a juror. And because of the way the law is, and we'll be explaining this, just to be absolutely clear, I have to say that this presentation does not advocate for jury nullification. That is, we are not telling you to go in and nullify. We are simply showing you the importance of jury service and to educate you about your options as jurors. And that is basically the disclaimer that I have to give to protect us from a system that does not want you to know what you are going to listen to and hear about and learn about for the next half an hour or so. So I'm going to turn it over to Kirsten. And yes, off we go with the history and mechanics of conscientious acquittal or jury nullification.
All right, and if we can go to the next slide, we will use that to tell you one of the hugest secrets in the American jury system today. When you are called for jury duty, you will be told that you have only two options when you are sitting on a jury in a criminal trial. In fact, you have three. But let's start with the two that you will be told about. And this may sound familiar to many of you. You may be told in jury instructions something to the effect that if you think the state has proved its case beyond a reasonable doubt, you should convict. Or you might even be told you will convict or you must convict. But if the state failed to convince you beyond a reasonable doubt that the law is broken, you must acquit. Now, the traditional language was should convict, must acquit. But that has moved stronger and stronger toward will convict and must convict. And that is a lie. The legal system knows it's a lie. Judges know it's a lie. Appeals courts have even acknowledged that it's a lie, but deemed it harmless error. And the reason why it's a lie is on the next slide. And the next slide tells you your third option that you will not be told of once you are in the courtroom. If you don't come in knowing about this, you're not going to hear about it from the judge or the attorneys. And that is this. Let us say that you believe beyond a reasonable doubt that the law was broken. You probably were told by the judge that you should or must or will convict. But in fact, you can decide maybe that the conviction would increase the harm in the situation, or that it would be unjust, or that there may be unjust punishment. And in fact, you may acquit. And all you have to do that is vote not guilty, just the same as you would if you thought that the case had not been proved beyond a reasonable doubt. So just to recap, three options. You think the case has been proved beyond a reasonable doubt, you may convict. You think that the case has not been proved beyond a reasonable doubt, you must acquit. But even if you think that the law was broken and that was proven beyond a reasonable doubt, you may still vote not guilty. And let's go to the next slide. Now, what is jury nullification? What is it for? Jury nullification is the term for that third option I told you. And it enables the community to quote unquote nullify. And a lot of people don't like that word, but it's the most common term for this. So we'll use it frequently. But it enables you to nullify a bad law or an unjust outcome. Now, just because a criminal case ends in a not guilty, even though it was proved beyond a reasonable doubt, that doesn't take the law off the books, but it does mean that person is not going to be punished that day for that thing. And it serves a crucial community function. Even though that law is not off the books, when you see certain types of cases being rejected over and over, that kind of ripples through the system. It ends up becoming a subject of legislation where they will repeal those kinds of laws. A great example of that is alcohol prohibition. And so that is how it kind of ripples through the system. You start seeing police not even bothering to arrest for it, prosecutors will decline to prosecute because they're just going to be embarrassed in court. And if we can go to the next slide. Now, the definition of jury nullification is when you acquit, not because you felt that the law wasn't broken, but you acquit because the law is unjust or that the conviction would create a moral wrong, regardless of whether that person in fact committed the offense. And we'll move to the next slide. Now, once your jury returns a verdict of not guilty, it's over. The prosecution cannot appeal that because of a clause in the Constitution known as double jeopardy. You cannot be tried twice for the same charge in the same jurisdiction. We won't get into the finer details of that, but that's kind of the basic concept. And you as a juror cannot be punished in any way for refusing to deliver a conviction. That's simply it. You can't be punished and there is no redo. And let's go to the next slide. And so that is when the entire jury agrees. So we've recently had Supreme Court rulings that say you can only deliver a guilty or not guilty verdict in a criminal case when all the jurors agree. But sometimes you're going to have a situation where not everyone agrees. Maybe people aren't sure of the case and it's like 8-4 split. Or maybe there's the lone holdout juror situation like you may be familiar with from 12 Angry Men, for example. Regardless, if the jury can't decide on a verdict, the judge has to declare a mistrial at some point, and then what happens from there varies. The prosecution can decide to start the process all over again, or they may decide not to. They may feel that it's not worth it based on what the split was between the jurors. They may offer a better plea bargain. The defense may be in a better position if there is a retrial. So even though you may be discouraged from returning a hung jury, there are definite advantages to someone for not being convicted. And I think Catherine's going to talk a little bit about that on the next slide.
Yes, so I'm pretty sure that everybody in grade school was told that jury duty, it's a civic duty, it's what good citizens do, and it's portrayed as kind of a drag, but like going to the dentist, you know, that's what virtuous people do. What we want to posit here is, in fact, jury duty is a political act. It is just as political as marching in the street, just as political as voting, because it is a way to reflect your values and the values of your community. So that just because the police have arrested somebody, or just because a prosecutor is seeking, you know, a mandatory minimum or the maximum punishment, if you think that, you know, dealing marijuana, for instance, really is not worth throwing a life away, then you can fight back against the judges and the prosecutors and the system that is trying to impose their will, because they're the ones that made the laws, on your community. And so basically it is a way of signaling that yes, the accused person may have done something illegal, but the enforcement of that law is going to cause greater harm to our community than whatever harm is caused by the act itself. And I find it very interesting that when someone is picked up for a drug crime, and the prosecution has to sort of map out exactly what happened. And one of the things they have to say is who's the victim. And with a drug crime, they'll say the victim is society at large. Well, society at large is you. And if you don't feel like you're the victim, you can say that and indicate to society at large, or to the people that hold the reins of power, that in fact, no, in this particular case, using drugs should not be a crime. It's an illness and requires care, not throwing somebody in prison. Next slide. So basically, the jury is the circuit breaker in the state's machinery of justice. And this is from a Supreme Court case from 2004, in which the Supreme Court did underscore the power of the jury in the courtroom, and said, just like, we the people keep our power in theory by voting, we the people keep our power and voice in the judicial system by acting as jurors and doing what we think is right. So next slide, if I could get it. So a sort of romp through history of jury nullification. Jury nullification was absolutely accepted practice up until the 1800s. Basically, back in the day in merry old England, with people in a small village, in fact, you could not be a juror unless you knew the defendant, because the idea was that you understood, you knew the defendant, you knew the plaintiff, you knew the context, and therefore you could bring all of that knowledge to the particular conflict at hand and come up with the best solution for accountability and reducing harm. And so, John Adams here saying, yeah, the judge can tell you to do X, but if your gut, your heart, your conscience says do Y, then you should do Y. Next slide. And then in the 1800s, things started to shift. And basically things started to shift because the jurors, who were of course all white male property owners, began to lose their monopoly on the jury system. And so you have your first nullification of jurors refusing to vote to convict for violation of the fugitive slave law, which of course made white slave holders very angry. You have Reconstruction, where for a very brief time, it looked like African Americans were going to be able to exercise political power. You have immigrants flooding into the country. You have workers beginning to organize and assert their rights and their position in society. And as it always does, the establishment struck back. And so by 1895, the Supreme Court is saying, what? Conscience? Jurors should vote their conscience? No. Basically, jurors should do what they're told. The judge will tell them what the law is. All they're supposed to do is determine the facts. He said, she said, who's right? And then we, the judge, the prosecutor, will take it from there. Thank you very much for your service. So next slide. And that continued through the 20th century with the courts denying the right when a defense lawyer would ask for jury nullification instruction. That is, the defense lawyer says, hey, I want to tell the jury that, if they think that a conviction would be unjust in some way, they don't have to convict. Judges are absolutely not. And so we then, by 2019, get into this crazy situation where jury nullification is a power that the judge should try to prevent juries from exercising. So no one is denying that jury nullification exists. No one is denying that jury nullification is embedded in the law, but the entire system is set up to make sure that jurors don't know about it. And so this is a super secret right that you have, and in direct contradiction to what a right is supposed to be, you're not supposed to know you have it. Next slide. So Kirsten, remind me when you take over. Sorry.
Let's see.
Yeah, I think
You have a couple, you have
yeah,
some more slides.
I'm still on. Okay, great. Sorry about that. I love this. So basically, the judges have come up with this hair-splitting notion that juries have the power to nullify, that it's like it's inside of you, but that the judge needs to do everything he or she can to make sure that you never figure out that you have this power. And so that is why we are having this training. And that's why we had that mealy-mouthed disclaimer at the beginning, because we have to, or at least I as a lawyer, have to say, gee whiz, I'm not really telling you that you should nullify. I am simply telling you that you have the power to nullify. So that is basically, makes sense to lawyers, makes no sense to anybody else, and is just another example, of which there are zillions, where the law and justice really are divorced from each other. So next slide. So basically, when you go into into a courtroom, you are going to essentially be bullied into believing that you have to do what you're told. And the judge is going to tell you, you have to uphold the law, whether you believe in it or not. You're going to be asked whether you could, vote to convict if you didn't believe in the law. And you can and will be removed from the jury if they figure out or think or suspect that you are trying to nullify. So we are going to be giving you some guidance, I guess, later on in this workshop on how to navigate that. But first we do, and we have a wonderful panel for this, sort of want to delve into how this works in terms of conscience and how you reconcile the kind of scary language you're going to hear with what being a juror really and truly is all about. So next slide. So if you, come away with nothing else from this workshop, please remember this very simple mathematical equation that Kirsten has gone into, which is you cannot be punished for rendering a not guilty verdict. That is one thing that the legal system has not figured out how to get around or subvert. And as Kirsten also said, acquittal is final. Again, that is one of the bedrock principles that still is holding. And those two combinations, you can't be punished and acquittal is final, means that jury nullification is always an option. It is in the DNA of our judicial system. And regardless of what the judge and the prosecutor and everyone tell you, and everything you write and everything you sign, this remains the fundamental truth, which is nullification is part of the law. And so I will now turn it back over to Kirsten to sort of break down this theoretical stuff into the kind of more practical steps of what you need to do and know in order to be a conscientious juror.
All right, let's go to the next slide. One of the reasons that the Fully Informed Jury Association exists and that you all are here today is because once you show up for jury duty, no one's going to tell you this. In fact, they will try to misinform you. So it will be too late for you to learn about this. So I encourage all of you to share this information far and wide after we leave here today, because community knowledge is crucial. This is a great tool that you can use, but you can only use it if you know that you have it. And I think we just did some significant work towards introducing it, and we'll continue to do that for this teach-in. But then you need to know how to use it. And again, how to use it, vote not guilty. That's it. Moving to the next slide. Now, don't look to get on a jury for the express purpose to nullify. You probably can't anyway, because as you will kind of see, I hope, during our upcoming exercise on jury selection, that lawyers are trying to weed people out for that. Just know that nullification depends on the totality of the situation, and it is a decision in which you should consult your conscience and base your decision on that. Next slide. Now, we'll be going through this in an exercise coming up a little later in the workshop, but it will probably help you understand it better if you pay particular attention to this slide. When we are doing jury selection, there are two ways that attorneys can deselect jurors from the jury, prospective jurors from the jury, i.e. make sure they don't get seated on the jury. One is called a strike for cause. And a strike for cause is something that indicates you can't be fair and impartial. So for instance, maybe you say something, you answer a question in a way that shows favoritism for one side or the other. Or perhaps you say something that isn't true, and this is something in this digital age to keep in mind, because especially in the most serious and high-profile cases, attorneys will look at things you've posted publicly on social media, and if they catch you in a lie, not only will you be stricken, but you can be in legal trouble for that. You may also be stricken for cause if you show animosity towards lawyers, the court system, or police, and we're going to help you deal with that if those are indeed your feelings. But know that that can get you stricken for cause. There are an unlimited number of strikes for cause. So that is going to play a key part in your strategy when going through jury selection, as you'll see later. The second kind of challenge is called a peremptory challenge. And this is something that each side only gets a limited number of. And they can use them for pretty much any reason they want, with a few exceptions. But those exceptions are sort of token exceptions, the way that the law exists right now. You cannot legally use a peremptory challenge to strike someone because of their race, because of their sex, and depending on what jurisdiction you're in, a few other reasons along those lines. However, it's very common for people to do that, especially when prosecutors want to get rid of people of color who may be sympathetic to a criminal defendant. They will not outright say, okay, I'm getting rid of all the Black people on this jury, but they will use things like neighborhoods or personal information as a proxy so that they have a token excuse to do that. So they may be asking you personal information about where you work, where you live. They may even use your appearance, whether they felt like you were paying attention enough, or like if they thought you understood. Very easy to use those as a proxy for these illegal reasons. The key here is that peremptory challenges, there are only a limited number, maybe 5 or 7 or something like that. So if you are going to get struck from a jury, do your best to make them use up one of their peremptory challenges. Don't give the prosecution any excuse to strike you for cause if you can help it. And moving to the next slide. A little advice here of what to do and how to behave when you are called for jury duty that will help maximize your chances of getting on the jury. You want to dress in a way that helps you blend in. Typically, courts will have a little bit of a dress code specified that is along the lines of business casual. Don't put on your t-shirt with the marijuana leaf on it. Be polite, but don't seem like you're excited to be there. A little bit nervous would be normal, but don't be like, I'm so excited to get on this jury, let me on. That will get you kicked off. If you have something to read with you, I'm gonna say not, Guns and Ammo magazine, not High Times. Bring something like People or maybe a drugstore novel, something that you might find in an airport bookstore. And when you're talking about things with your fellow jurors, keep it neutral, nothing about the political environment or anything like that, nothing about the law. Sports, hobbies, if you have pictures of your grandkids, something like that, very neutral. Don't express your opinions about politics, criminal justice, or social issues. Please keep that to yourself. Don't be excited to get on a jury. Don't be memorable. Just try to blend in. And I will underscore this again, do not lie. You can get in legal trouble if you lie. So do what you can to express things truthfully but neutrally, but definitely do not lie. Next slide, please. All right, some examples to help you out. Let's say you are asked about what you think about cops or police. All right, I know I have my opinions. I'm sure you have yours, and we want to express them in ways that we are passionate about. But consider, instead of saying, hey, I think cops are liars, say, I'd have to hear the police witness to decide if they're telling the truth or not. That is truthful for me. I bet it's truthful for many of you. The fact that you might be likely to find them untruthful doesn't need to be said. If you're asked about your thoughts about drug laws, you may be inclined to say, hey, this is not a crime. This should be dealt with in the healthcare system. Keep that to yourself, please. Just say something that is going to blend in, something along the lines of trafficking drugs causes harm to society, or whatever other thing that you think is truthful but neutral. If people ask you, what do you think about the fairness of the legal system? Hey, we all have a lot of opinions about that, I'll bet. But instead of saying something very frank along the lines of mass incarceration is slavery 3.0, just express something neutral to the effect that the race of the defendant will not affect my ability to judge this case. The gist you want to give is, I am committed to a fair and just trial, and I bet for all of us that is true. I know it is for me. Next slide. And back to Catherine.
Yes. So I think we all have a kind of a gut instinct when people are asking us questions that somehow there is a right answer. And in this particular case, this is not an exam. You do not have to answer the question in the way you think they want you to answer it. You do not have to directly give them the information that they are asking for. You just have to say something that is vaguely relevant, and preferably utterly banal. And I just highlight this because through however many years we have all been on this earth, we have been socialized to, when someone asks us a question, to give the best answer we possibly can. And in this particular case, that is not what is required. So it is going to require an adjustment So just kind of keep that front and center if you're ever in a situation where you're in a jury. This is, think of it more like a cocktail party where, you know, you're with a bunch of people that you really have nothing in common with. And you just need to kind of get through the next hour so that you can go home. Next slide. Okay, so let's say all of this works and you are on the jury. Hooray, halfway home. But you still need to be a little aware of your surroundings, because even if you're on the jury, if somebody gets wind of the fact that you are going to nullify or open to nullification, you can be removed from that jury. And although the jury is kept separate and, you know, prosecutor and defense lawyer and judge cannot, you know, overhear any of the deliberations, one of your fellow jurors can rat you out, and they will. So you need to read the room. You need to figure out who, you know, the folks are that maybe think like you. Identify the rule followers and steer clear of them, and then listen to the evidence. I mean, you do have to just give everybody a fair shot at giving you their side of the story. And I'm now going to speed up because we are behind time. So if I could get the next slide. So if you find yourself standing alone or with one other person, we need to acknowledge that that is going to be a very difficult situation. You are going to be alone in a room. There's going to be a lot of peer pressure. Everybody is going to want to get this over with, go home. And if you or you and a couple of people are standing in their way of picking up their kids from daycare, it's going to get a little tough. But you can say, I mean, you should say, and nobody can, you know, fault you for this. You don't find the witness credible. You believe an alibi witness. You're not convinced beyond a reasonable doubt. And you've considered the evidence and listened to the jury and you've made your decision. All of those things you are entitled to say, and nobody, you know, they can't go to the judge and say this person is blocking a verdict because, you know, they don't find a witness credible. That's what you're there for. Next slide. And this is just a hint at the panel that is to come, but they will also lean on you. You swore to uphold the law. You said that you would render a verdict according to the law, so help you God. And just remind yourself, jury nullification is part of the law. So you are doing what you swore to do. Next slide. Yep, there I go. I preempted myself. Next slide. Okay. If you find yourself in the minority, the judge is going to try and guilt you into making a decision. Judge is going to call the entire jury in and basically lecture you and say, you know, if you don't reach a decision, you're not doing your job. Look at all these terrible things that are going to happen. Your taxpayers are going to have to pay for another trial. Everybody is going to have to do extra work. So just go back there and make a decision, i.e., you holdouts just, you know, go with the flow. And so I am just going to quote Kirsten and Efja. You have the right to hang the jury. That is, you have the right to make them do it all over again, because you are not going to convict simply to get along. So you have a right to hang the jury. You do not have a right to compromise someone else's life away. And so if you find yourself in that position, just remind yourself you are saving a life, because you are. And I think the next thing was questions, and we don't have time
Definitely
for
not.
questions. So
What we are scheduled for next is a break. We're running a little behind, so we're going to shorten up the break to about 10 minutes and reconvene at 11:15 a.m. Central Time, or a quarter after the hour. So I hope you're all back on time for that, because we will be hosting the faith panel next, and that I am very excited about. So we'll see you at 11:15 Central Time.
Feel nothing but heartache, but I sing more than the blues. We're at the hand of a man who has trouble overstanding the plight and the cause, yes, the universal laws. These are troubling times. These are troubling times, man. These are troubling times, Lord, have mercy. These are troubling times, all right. He profiles racially. He discriminates sexually. He persecutes religiously and says us is no longer we. These are troubling times. These are troubling times, man. These are troubling times, Lord, have mercy. These are troubling times, all right. Just 'cause I got a little slang in my talk, and I got a little rhythm in my walk. Somebody told me it was just cause for me to be somewhere outlined in chalk. Ooh, these are troubling times. These are troubling times, man. These are troubling times, Lord, have mercy. These are troubling times, all right. Can't find no job, but he drives a fancy car. Keep looking for peace, can't find nothing but war. Ooh, these are troubling times. These are troubling times, man. These are troubling times, Lord, have mercy. These are troubling times, all right. Just 'cause I got a little slang in my talk, and I got a little rhythm in my walk. Somebody told me it was just a cause for me to be somewhere outlined in chalk.
They say time heals all wounds. I don't agree. Every wound leaves a scar. They're all over me. They remind us where we've been, and they teach us where to go. If you haven't forgiven, it's time to let them know. I know you're lost, but it's okay. We've all got scars. You are not alone. Don't turn your back. Don't look away. I know your heart. It's time to carry on. A kid afraid of the dark, of what he can't see. Somebody scared of the light. Now that's a tragedy. Don't run and hide. Just because there is a storm, if you keep your head high, you will find your way home. I know you're lost, but it's okay. We've all got scars. You are not alone. Don't turn your back. Don't look away. I know your heart. It's time to carry on. I know your heart. It's time to carry on. I know your heart. It's time to carry on. I know your heart. It's time to carry on.
I just wanted to let you know that we have about 1 minute left for our break, and then we will be coming back at exactly 11:15.
I've been walking with my face turned to the sun. Weight on my shoulders, a bullet in my gun. Oh, I got eyes in the back of my head, just in case I have to run. I do what I can when I can while I.
I hope that everyone enjoyed their break and that you all are ready to dive into the next section, the next part of our teach-in with our panel discussion. So I'm going to turn it over to Kirsten.
There we go. All right, excellent. All right, welcome. So I think we have with us today Avalon and Naomi, who have introduced themselves. We have a third possible panelist who hasn't logged on yet, but if he joins us, we will wrap him in. We have already discussed the legal questions surrounding jury nullification quite a bit, and now we're going to shift gears, because even though people know sort of the legal, have a good legal feel for whether they're allowed to do it and how to do it and all of that, we often have people who have sort of ethical or moral concerns about what it takes to do that. And so we're going to have a little bit of a discussion today centered around a few questions, but we may wander where it takes us. If you have questions in the meantime, please type them in the Q&A section. For me, it's at the bottom of my screen when I hover my cursor over the bottom of the Zoom window. And we have some time set aside for that. But in the meantime, let's get started. I'm hoping that we can kind of we prepped a couple topics in advance, but having heard some of what's gone on already, I wanted to reverse the order a little bit and start off talking about oaths. Naomi, I took some notes during your opening comments, and you made some great points about oaths being used to silence critique. And you advanced the idea that is very powerful and some might consider a bit scary, of breaking vows as tools of community healing. Now, can you talk a little bit about the conflict that people of faith may have in taking oaths to uphold the law, which is often something that they are coerced into in jury trials now? There used to be a general oath that said you would render a true verdict and do justice and this sort of thing. But now people are being asked to take an oath that says that they will uphold the law as the judge explains it to them. And we know that judges don't explain that correctly much of the time. Can you talk a little bit about that? And then Avalon, perhaps you can weigh in after Naomi.
Sure, yeah. So, what's on my mind is how we learn what oath taking really is and what it symbolizes. I mean, I know that I remember I grew up in a fairly conservative Christian school environment. I had Christian schooling until high school. And we pledged allegiance, right, which is taking a vow, making an oath, to both the American flag and to the United States and to the Christian flag. So I just want to name that for many people of faith, part of faith formation is this idea that we are pledging our allegiance, pledging our loyalties to God and perhaps even God and country. And so I just want to name that there are already ways we are socialized, both in political space but also in religious space, around vow taking and around oath taking oaths. And yeah, I think that what we've certainly seen over the last couple of years is a resistance by some people of faith to make vows other than the vows they've made to God, or that certain other obligations, like, a commitment to Black Lives Matter, for example, commitment to say that, to a vow, a duty, an obligation to live into a commitment that Black Lives Matter is in conflict somehow with one's vow and commitment and oath to their Christian identity or to the God of their understanding, right? And so I do think that these are conflicts that we often don't surface, that aren't made explicit, that people are just wrestling with internally. I would want us to, as I was kind of hinting at in the opening, I want us to question all of it. I want us to interrogate the kinds of vows we think we're making to God, and interrogate whether or not God is actually requiring such, or what is the nature of the vow that God would ask us to take, right? And is that the same as the vow that the judge asks us to take, or that the legal proceeding asks us to take? And how did those things get conflated, right? So I'm so appreciating your and Catherine's explanation of how we got to look with such disdain and contempt on jury nullification, right? And so we know then that some vows, some oaths are preferable to others, right? In a legal sense. So I guess what I'm trying to say is I want to put all of the vows on the table and really sift through the whole process of oath taking, as a precursor to perhaps the resistance, the invitation to resistance that we might choose to accept when we get called to jury duty.
Yeah, so I am in total agreement with 100% of what Reverend Naomi said, and the only part that for me, where I am as a person of faith, is that and as a person of Christian faith, so this is specific to my faith, is that I go back to who is the center of my faith. And in thinking about the oaths that we are required to take in this system, where is he, as in Jesus Christ, in relation to that oath? What is his position on that particular oath? Again, I'm not saying going in there with the intent to deceive, right? Because the system deceives us every day. I'm saying instead go in with the mindfulness and present of mind to say, okay, where is my God, my faith in this oath and in the actions that I have to partake upon in this process? And that to me asks a slightly different question. And so when I go to take my oath, I am taking the oath because you have to take it, right? So I am going in taking the oath with that at the forefront. Like, where it are the tenets of my faith in this process? And that is where I'm going to look at the law. But if I've deemed, like the Fugitive Slave Act, if I deem that law immoral, illegal, and inconsistent with my faith, then I am not going to uphold that law. If I deem that Christ, who on the cross told the criminal, you will be with me in paradise this day, right? You will be with me in paradise this day. That was a redemption situation. How can I exercise that same love in this process, right? How can I use my role as a juror to heal and not harm? Like I am big on harm reduction. And so I don't want to cause more harm. And so for me, going in, looking at that oath, taking the oath, because you're required to take it, it is taking it with the understanding that I am putting the tenets of my faith in that oath. And I am looking at those words from that perspective, not from the perspective of the judge who thinks he or she is God.
Yeah.
So that's my thoughts on the oath taking process.
Wonderful. I see Daryle on screen now, so this is a great chance to roll him in. Daryle, self-introductions seem to be the order of the day. So if you would briefly introduce yourself, that would be great. And then I have a question for you about oaths.
Yeah, Daryle Brown is my name. I am, my day job is as the Executive Director of Multimedia and Communications at Trinity United Church of Christ. But my passion work has been in prison ministry for over 20 years now. Specifically the last 11 years or so, focused on advocacy work around ending mass incarceration. And part of that work has involved engagement with the whole idea of jury nullification. And listening to Avalon talk about not leaving your faith at the door when you walk into a courtroom. To be honest, I hadn't thought in depth about these oaths and what they mean spiritually and theologically. I know that in the Bible it talks about the only appropriate person to make an oath to is a government official, a magistrate, right? So I mean there is some of that in the Bible, but I'm gonna tell you, for me, and I'm just going to put it out there. I'm in the midst of, I'm in the last stages of my Master's of Divinity, my theological education, as it were. And I I have a very I have a very tough perspective on on the Christianity becoming the religion of the state, right? So when Constantine decided that, okay, Christianity is going to be the religion of the state, for me, from that point in time, I look at evolution of my faith with a side eye. I I interpret things um, from an understanding that what was the state interest in this change, right? So for me, and what's the alternative? Is the alternative for people of faith never to serve on a jury? That don't sound like a good compromise, right? So, yeah, they're going to make you take an oath, and if I was on a jury, I'd have my hand up taking the oath right along with everybody else. But like you have, Lon, I'd be talking to Jesus too. I'm like, Jesus, I took that oath, but they railroading this young man.
Mhm.
So I hear you, and I think it's a conversation worthy of. I need to bring it up with some of my more studied theologians and kind of get their real take on it. So I'm taking that back to class next semester.
Awesome.
I'm gonna get some real, that 45-year theologian
Yeah.
perspective on it, because this is, like I say, I'm in learning mode still, but at the end of the day, I think you hit it. There's nothing that man can make a law of that makes me leave my faith at the door. I mean, there's one top level authority in my life.
So I wanted to run kind of this perspective by the three of you. I think most people think, oh, either I'm going to take this oath and then I'm going to have to break it if I want to nullify, or the way I avoid this moral conflict is to simply not take the oath, which means that accused person probably won't have a fully informed juror on their jury. And I suspect, but I don't want to speak for anyone else, that we all think that's a terrible, terrible deal.
Yeah.
So I've tried to figure out how I can, kind of put it in my head. And what I came up with is this: when I take that oath, I am taking it in good faith that I will follow the judge's instructions. But the flip side of that is their good faith side is that they have to instruct us properly, and that includes jury nullification. And when that gets broken on their end, I feel like that releases me to some degree from my oath. Is that something that any of you find palatable or objectionable? And what are your thoughts? So let's start with Naomi.
Yeah, I mean, the oath is. Here's the thing. I think that the oath is an invitation to act according to one's conscience, according to one's understanding, right? So I think this is part of the narrative shift that needs to happen around oaths, and particularly oaths in a legal context. You're not swearing to do a particular thing or a specific thing. You are, in some ways, you are committing to a particular kind of posture of close listening, deep listening, of sorting through and sifting through the materials presented, and of acting in a way that aligns with your conscience, your understanding, right? And so I think that the railroading is in that the culture has taught us that we're taking a specific vow. In other words, it's an attempt to seal us into a particular kind of perspective, I think. Versus it's an invitation to take seriously, right, the task of thoughtfully wading through the information, listening well, and being a full human being, right? I so appreciated that history lesson about how service on a jury at one point was an honor, an invitation to um, to deliberate about the life of somebody that you know, that you're in community with, in a relationship with, right? And so the vow is an invitation to be fully human, and to thoughtfully make a decision according to one's own conscience. So for me, I don't need to find a loophole in order to be able to participate. The oath is a broader invitation than we actually want it to be. I think want it to be.
I love that. I was scribbling down notes frantically. Avalon or Daryle, do either of you have some additional thoughts on that?
Well, I was just going to ask the question. Did we actually read the oath when we started the conversation?
No, because there isn't an oath.
Different states have different. Okay.
Yeah, I actually was watching the Derek Chauvin trial because this, and I looked up Minnesota's standard oath in law. It says you give this oath or something substantially similar to it. And the oath that was given in the Derek Chauvin trial, I think, was substantially different from it as well, because it had jurors essentially saying, I will do what the judge tells me. So we didn't. Avalon?
And that's really, kind of, I'm sorry, go ahead, Daryle.
I was just going to say, I really appreciated Reverend Naomi's perspective on that. You know, it's an invitation to bring your full consciousness as a human being into the jury responsibility, and just what I tell people is that when you serve on a jury, you are an equal in the courtroom. You're an equal to the judge, you're equal to the defense attorney, you're equal to the prosecutor. You are one more player in the justice drama. Don't throw that away. Don't let people talk you out of your power. Our brochure that we hand out every now and then at courts says, it's titled "Knowledge is Power." Don't throw your power away. I'm sorry, Avalon, go ahead.
Oh no, that's fine. I just want to just kind of say the same thing. I agree with Reverend Naomi, and I actually like how she explained it, that it is an invitation to bring your whole self. Because guess what? That prosecutor is bringing his or her whole self to the situation. The judge, in determining and ruling on motions and all of that stuff, he or she is bringing his or her whole self into that moment. And so why would the jury be prevented from doing the same? I remember, and I'm just kind of paraphrasing, when the whole nomination process and hearing process was going on for the new justice. What's her name? Barrett.
Amy Coney Barrett.
Amy Coney Barrett, right? And part of the discussion was that, of course, judges bring their own personal views and their perspective in judging cases. So why would a jury be not allowed to do the exact same thing? And so for me, I feel like it's and then to add to the fact that I feel like jury nullification was disappeared as a result of white supremacy, racism, bigotry, misogyny, right? So you don't get, we're not even in the same place now, right? Because your oath has all of those things that I wholly disagree with built into it. It's based on sustaining that system. And I don't need to be a part of that. My oath is based on my system and me being the person that I am coming to into this space. And so I don't I don't feel like I have to find, again, a loophole um, in in taking that oath, because that oath to me is rooted in racism, white supremacy, bigotry, and I'm not taking that, and I'm not going to pledge allegiance to a person, right? Like Peter said, shall we disobey God and obey man? Like, I'm not going to do that. I'm not taking on your racism. I'm not taking on your misogyny. I'm not taking on your white supremacy to do my job as a juror. So my oath is my oath, with all of those components and all of me and all of my perspectives rolled into it.
So Avalon, something you said kind of provides a little bit of a nice transition to another one of our topics, which was juror objectivity. By the way, if you hear any dog noises, I'm house sitting a 90-pound dog who just busted into the office. So I apologize for that. So one of the things that I think Naomi mentioned earlier, and Catherine, was that it used to be jurors were not selected because they knew nothing about the case. They were selected because they knew things about it, and that was important to deciding it. But now we have this, I think putting it as a myth, as Naomi did, is perfect, but this myth that if you go into the courthouse, you're supposed to be a blank slate. Not only do you not know anything about the case, but you don't have any opinions about anything. You're not socially aware of anything that's going on around you. And anyone who can think about it for a minute, that's just ridiculous. And yet somehow that has become the image that people have of a quote unquote proper juror. And I wanted to see what all of you thought about how that presents moral or ethical issues for people, and especially people who may have themselves dealt with the criminal legal system and been personally traumatized as a result of their contact with it. Does it, any volunteers to get us started on that? We'll go with Naomi then. Oh, we got Daryle.
One of the challenges, of course, to even getting sat on a jury is answering all these questions that are put in front of you. And of course, then the attorneys have the right to strike you for just about any reason. I mean, the whole idea, and the Chauvin trial is a perfect example. No, it is no way possible unless they found a cave somewhere to find somebody that knew nothing about this case. But yet they wanted to pretend that that was part of the selection. They wanted to say that we can't hold a fair jury here or a fair trial here because we can't get jurors that don't know about the case. Come on. There was no, you couldn't find a juror in the world. You couldn't have took that case to Outback Australia and not have people know about the case. So, you know, it's the Avalon has made just wonderful points about the whole ludicrous nature of what the myth that they want us to believe. And I apologize, Reverend Naomi, that I didn't get to hear some of your earlier comments because I'm sure they would have fed my soul. I got to go back to the recording to catch up on you because I'm sure it's going to educate our whole processes going forward.
I just want to.
Oh, I'm sorry. Go ahead.
I just want to quickly invite people to ask your questions in the Q&A section. I saw a question from Greg in the comments that we'll cover at the end. But if you have any questions for our faith leaders, please feel free to ask them in the Q&A. And if we don't see questions, we'll just keep going through our allotted time. And Avalon?
So I just kind of wanted to add that it is ludicrous to have a different set of standards for the jury than everybody, all the other players in that system. But I also want to add this. The reason why they do that, it is to perpetuate this facade of being blind, of the lady of justice being blind. See, so if I have jurors who are blank slates, then that gives credence to this fallacy that the Lady of Justice is blind, right? And so, and we know that because, like, as you know, so eloquently taught in your session, that what the jury decides is final, and we know that's true even if they decide to convict, thanks to the finality of judgment doctrine, right? So few bad convictions are overturned, so we know that a conviction or an acquittal is pretty much the final say, and they need to have uh, this facade of legitimacy. And built into that is this notion that the jury needs to be a blank slate. And that's the hill that they've um, put their flag on to bring more legitimacy to the system that, in my opinion, is illegitimate. And so for it's kind of one of those things where, you know, they set this standard up so that it could be a self-fulfilling prophecy. And that's the story that's sold to the society. And I can say for years, I believed it until I lived it and realized, oh, wait a minute, this is not what's really going on here. And so I think, so for me, that's just another reason. Like, I'm not going to give you that cover. I'm not going to be a party to giving you that cover. I'm going to expose you through my actions and my deeds and my participation in this, fully committed to doing what I'm constitutionally mandated to do, with all of me. But I'm not going to just give you that cover, Willie. You don't get that for me for free or at all, actually.
Naomi?
Yeah, I would just add that again, part of the culture and narrative shift that needs to happen is that, you know, we actually don't trust people. We don't trust that, you know, outside of the prescription of the state or the status quo power, um, uh, the people in status quo power, folk just don't know how to be and live and do, right? And so again, what are the forms of knowledge and understanding and interpretation that we privilege in our society, right? The law becomes the primary text, the primary lens through which we interpret life. The law becomes the barometer of morality, right? But we know that there are other ways of knowing, there are other ways of interpreting life, there are other ways of evaluating morality, right? And so when we ask people to come and I guess erase their minds, erase their memories, to forget their trauma, forget their prior experiences and engagements with the system, we are saying that we actually don't think that your ways of knowing are legitimate, and that the law somehow rises to the top as this objective lens through which we can interpret our lives. And that's just, we know that that's not true. We know that, as Avalon said, these things were baked into the law, right? What was codified in law was a particular perspective,
Mm-hmm.
right? That we now think is you know, somehow untouchable, and somehow untainted by human perspective, or human subjectivity. And that's just, as you say, a fallacy and a myth. So, you know, as a juror, you say that the text of my life is a sacred text that I use to interpret what happens around me. And no, I'm not checking that at the door, as Daryle was
Yeah.
saying.
Yeah. Although they're not very common, death penalty cases are notable in that jurors who are selected for them go through what is called a death qualification process. And essentially what it means is that if you will not say confidently enough, apparently, that you would consider a sentence of death as well as a sentence of life, you will be removed from the jury. And of course, most people who are willing to consider a sentence of death are willing to consider a sentence of life without parole, but not everyone who is willing to consider life without parole thinks that they would be willing to consider a sentence of death. So this ends up skewing the jury because supposedly they can't be objective or fair and impartial. Does anyone have any comments for folks who may get called and deal with that process about what they can do to get on that jury, yet still feel like they are being true to their conscience, capital punishment?
Well, okay, so, and this is my how my brain works in that situation. Whether we're talking about literal death or figurative death, regardless of the situation, every criminal case involves a form of death, right? All of them do. So in my mind, I'm thinking, if my conscience says that I should in fact vote to convict, I have given that person's life a death sentence. They will forever be labeled as a convicted person.
Mm.
So that their whole reputation, their identity has been killed in that moment and has been replaced with a new identity. So I feel like that there's a figurative death that happens regardless when you convict. And the system, in going into that space, there could be, probably not likely in my own personal situation, a situation whereas I felt like, okay, a conviction was necessary. Now, whether that, I don't distinguish. I mean, there is a substantial difference between someone not breathing anymore and someone being labeled a convicted person. I'm very clear about that. But for me, the harm, the initial harm is comparable. And so being able to answer that question, because and to add to that, life without parole, to me, if I give someone a 20-year sentence, a 30-year sentence, a 50-year sentence, that is only a different label, but the outcome is the same. I'm still convicting you and sentencing you to life. So I feel like we have these categories, these legal categories, to kind of make us feel better about what we're doing. And instead of just calling a thing a thing. Mm-hmm. And so I feel like if you go in thinking that I'm calling this thing a thing, and I know that I'm going to negatively impact this person's life regardless, if I convict, and am I willing to be able to take that step? Can I take that step? Mm-hmm. In my conscience? I think that's where the thought process needs to happen, not necessarily, and stop trying to put into these areas of gray, because to me, 20 is 50 is life is death. Mm-hmm. I don't say, oh, well, you know, they only up for 20 years. To me, I look at it as all the same. Even though I am not saying that someone who is breathing in prison is the equivalent of someone who is dead. Mm-hmm. I am not saying that, but I am saying that decision to do that is I don't see a difference in the thought process that I have to be a part of a jury that's going to give somebody a mandatory minimum, mm-hmm. versus somebody's going to give them the death penalty, versus somebody's going to give them life without parole. Yeah. That's just me.
Yeah. We've got a question finally from our audience. Thank you, Nikia. I hope I said your name correctly. They would like to know if we could share more about what about jury nullification in the case of violent offenders, and what are the considerations of returning someone like that to the community where they might do more damage, and what are some of the things that the community should be considering in order to decide whether to nullify or not nullify in those cases. Daryle and then Naomi, would you?
Yeah, and I
address
would
that?
just say that, jury nullification is not to be taken lightly. Okay. The fact is, it's a two-edged sword. You better believe it was a whole lot of jury nullification going on in the South when they were lynchings and killings of Black folks during all kinds of situations in the civil rights era. There's a reason that folks never got found guilty, and they were practicing jury nullification. So it's a two-edged sword. We're not, I don't think anybody on this panel is saying serve on a jury and then let anybody off that comes before you because of jury nullification. We're serving on a jury with a conscience, and we're not going to put somebody away for 5 years for being caught with a 2 ounces of marijuana. Okay, that's where I got engaged with jury nullification, was in part because of work I was doing with Drug Policy Alliance. And you better believe that, our drug laws are some of the most heinous and racist laws that this country has come up with. And if there's a case for jury nullification, a lot of it could come into play in those spaces.
Naomi, we have about 2 minutes left. Would you wrap us up with some final thoughts on that, or any other thing of your choice?
Sure. I'm so appreciating Dr. Nikia's question. This, I think that the movement for justice and transformation of our legal system has to be multifaceted, right? So I think jury nullification is a tool, is an instrument that in a specific role you can use to subvert and undermine a system that would make you swear to uphold an unjust law or unjust proceedings. And I think we also, even we who are advocating for mindfulness as it relates to jury service, I'm thinking back to Catherine's disclaimer at the top of the program, at the top of the workshop. We also must participate in the work of imagining and constructing new forms of accountability in general, right? So again, it's not the case that people should not be held accountable for the harms that they perpetuate in community. And sometimes a timeout is necessary. Any parent, caregiver can tell you, of children can tell you, sometimes it's necessary for you to just stop. You need to be still for a while, right? And while you're being still, we are attending to your woundedness. We're attending to your shames. We're attending to your trauma. We are attending to your anger. We're attending to your sickness, whatever it is, right? So I think that the community at large has to be committed to not just this kind of one-off, let me get this person off, but a holistic reconstruction of a system of accountability that parallels, because, right, people are not going to sign on the dotted line for doing this kind of resistance if it is the case that means that the community then is made more vulnerable, right, to harm. So we got to do some work, parallel work, to create systems of restorative justice, perhaps, or transformative justice, where people are held accountable for the harms that they might perpetuate in human.
I sing more than the blues. We're at the hand of a man who has trouble overstanding the plight and the cause, yes, the universal laws. These are troubling times. These are troubling times, man. These are troubling times, Lord, have mercy. These are troubling times, all right. He profiles racially.
So we have just about a few seconds.
These are troubling times, Lord, have mercy. These are troubling times, all right. Just 'cause I got a little slang in my talk,
Oh,
and I got a little
all right.
rhythm in my walk.
I hope that everyone enjoyed the break and just the rich conversation and dialogue that we just had. I know I am still chewing on the nuggets of richness that were provided. So I'm going to go ahead and hand it over to Catherine. And then directly after the Q&A section with Catherine and Kirsten, we're going to move into to our final remarks with Naomi. And then Avalon and I will come back and we will send us on our way.
Excellent. Well, this has been really fabulous for us and given me a lot to think about and a lot of new perspectives. But I am just wondering if there are questions. I know there was one from earlier.
From Greg, I'm scrolling as we speak.
About, I think it was why can't
the defense attorney tell people about jury nullification when it's legal? I believe was the gist of that.
Yes, and the answer is because the Supreme Court has said that they can't.
I don't think that's accurate. It's
accurate.
A slightly finer point. The Supreme Court in Sparf v. United States in 1895, I believe, said that jurors don't have to be told about it. And so the environment at the time was that jurors generally, like as much as you know that that one day you're going to get a jury summons in the mail, that's how common knowledge of jury nullification was. So sort of the excuse in that ruling was, oh, we don't need to tell them about that. Everybody already knows about that.
Yeah, I think that unfortunately that has now been carried on to judges have an affirmative responsibility to make sure that nullification doesn't happen. And you're correct that the Supreme Court has sort of danced around that, but there certainly have been appellate level courts that have said that there is this affirmative responsibility that although the jurors have the right, they shouldn't know about it. And that has then taken the form of starting with denying, because if you want a specific instruction for the jury, you have to ask the judge. And so the judges started denying the jury nullification instruction. And then it just sort of changed to like, don't even bother. And so defense attorneys have pretty much given up unless you're someone like Catherine Bernard that just says it anyway. But as she said, she knew, well, she knew she was breaking the rules. She was told she was breaking the rules, and she did it anyway because she knew she could get away with it. But that's not how any kind of system of air quote justice should work.
I will say from non-Georgia states, I have very, very occasionally seen an attorney be able, or a pro se defendant, someone representing themselves, actually be able to overtly tell the jury about jury nullification. It's extremely rare. Right? So I think, I can't remember, I think it's called the Plowshares Movement. They're a peace activist group that throughout the years gets arrested from time to time. And I recall an article in which their attorneys like referenced sections of the Bible talking about your conscience in their closing statement. There is a that were people who went into a draft board office during the Vietnam War and just started bagging up draft files and then tearing up other ones, and were kind of caught in the middle of it. There's a movie called The Camden 28, which tells the whole story. But in their case, they had a couple of attorneys, but most of the people represented themselves. And a Catholic priest, Father Michael Doyle, you can find on YouTube where he reenacts his closing statement to the jury. And he basically talks about how no one can like take away their right to exercise their conscience and that sort of thing. So those are kind of the oblique sorts of things that are more commonly done in that way.
Yeah, I think we have a related question from Andrew, which is if we get summoned for jury duty, can we plant the idea of jury nullification during questioning? And I think that gets to the sort of broader strategic question of what is your goal? And so for me in Virginia, I got told I was in the jury pool, but said that because I'm a lawyer, I can opt out. And I said, no, I'd love to be a juror. There is no way I am getting on a jury. I may, however, get called to sit in the room to wait for a prosecutor to strike me. And in that process, if I could introduce the idea of jury nullification, I certainly would do so. Because I know I don't have a chance of being on the jury. So that, I think I said before, if you feel like you are going to get stricken, then by all means, educate the folks that are going to be left behind. Mm-hmm. If you think that you have a chance of getting on, then I wouldn't go in that direction, because if they get a sense that you are trying to nullify, or you're going in with that intent, or even with that possibility in your mind, then you're going to get removed for cause. So it's a real cat and mouse game, and obviously your thinking can shift, but you have to kind of decide what kind of resistance you are going to be exercising, whether it is directly in trying to see that justice is done for the defendant, or in a more general education / let's reform from within protest.
I just shared a link in the chat to a resource that we have on the Fully Informed Jury Association website, specifically designed for those called for jury duty. And I want to draw attention to the resource under item number 2 on that page. We have a link to a PDF file of a brochure called Surviving Voir Dire. And it's about 4 8.5 by 11 pages. So it's not like a quick 1-minute read or anything, but it does cover that, what to do if you think you can get on the jury. And then if you're like, okay, yeah, I kind of see where this is going, I'm not going to be on this jury, then maybe you want to transition to that other let's mention jury nullification to everyone angle. And one of the things it points out is you need to have a soundbite pre-prepped for that. There is no, soliloquy in court from a prospective juror. You will not have a chance to make your grand speech, no matter how wonderful it is. And I know everyone here would have quite a passionate speech in that way. But you need to be able to get it out quick, because the judge will get you out of the courtroom as fast as they possibly can once they think that you're going to drop a little knowledge on the person sitting next to you and hopefully down the row. All right, I don't know, let's see. I don't know if attendees can raise hands, but I don't see any hands raised. Does anyone want to, we have a few more minutes for Q&A. What I would really like to know is a thing that I am struggling to make sure I do right is have people understand how to nullify. So I just wonder if anyone could tell us in the chat, or if you want to unmute and maybe comment on this. Do you feel like you understand if you are there in deliberations and you think, you know what, I don't think that I'm going to convict this person, even though I believe that they committed this offense? Do you know what to do? Do you feel confident you would know what to do? And if so, put in the chat exactly what you, or maybe not exactly because it's the chat, but give us an idea of what you would do if you were in that situation, just so we can make sure that people understood that. So Linda says, do I understand correctly that in the jury room, I would not mention nullify, but would rather say innocent for this reason? That is basically the gist. And if you use the word nullify and one of your fellow jurors is like, oh, she's not following the instructions of the judge, or he's thinking about not doing this, they may send a note to the judge, and then you can't be punished, but you can be removed even during deliberations. So that is a great gist. And Avalon says you could just state that you don't feel like the prosecutor has met their burden of proof, which is a great way to go. The judge, I should point out, cannot like single you out and demand you explain your reason for a not guilty verdict. If someone says, oh, they're not deliberating with us, the judge may ask you questions, but he can't dig that deeply into your deliberations. So pretty much any general thing that suggests that you are participating in deliberations, but that you just disagree, will do. And it may take a variety of forms depending on what the case is and what small thing you can grasp at. But if I'm in a situation where it's all pretty cut and dried and I'm still going to vote not guilty, I may just fall back on something like, in my heart, I can't convict this person. And but it is important to make sure you are participating in deliberations. And you can do that without agreeing with the others in a variety of ways. You can ask questions, listen actively. What you can't do is, I'm done, I won't hear anymore. That sort of thing will basically get you removed.
Yeah, I think in terms of the question of how many jurors can be removed that way, I don't know that there's ever been a mass juror removal, but since there are usually only 2 alternate jurors, I think from a practical point of view, the number would be 2, because otherwise they have to declare a mistrial anyway, which is basically if you are alone or just have one other person, what the result is going to be. And I think you can always fall back on credibility of a witness, because that is such a subjective thing. They had shifty eyes or whatever it happens to be. it's very hard for someone to argue with your assessment of credibility because it's such a personal thing. There's no right and wrong about it.
I think if we could get Avalon to unmute, in our preparations for this, Avalon had some great comments talking about reasonable doubt and what that means, and talking about, is this possible? Avalon, would you share a little bit of that? Do you recall what I'm talking about?
Yeah,
Oh, good.
absolutely.
Excellent. Take it away.
No problem. I love sharing this story. So if you're really struggling with the whole jury nullification thing, like you just can't you want to do it, you want to do something positive or good, but it's just a bridge too far for you. Another alternative is, just as they have disappeared, the system has disappeared jury nullification, they've also perverted what the burden of proof is for the prosecutor. Well, actually, they've more so perverted what the burden of proof is for the defendant, although there constitutionally isn't one. Nevertheless, we all know that they have one. So what you could do is, if the defendant's story is possible, even if you don't believe it, that actually meets the reasonable doubt standard, because that's a possibility. That's reasonable doubt. So you could always fall back on the position of, you know what, I don't, whether or not I believe the defendant's narrative about what happened, it's possible. And therefore I don't, and then that's why I always use the burden of proof. That's why I put the burden of proof in the chat, is because that's my go-to. Well, they didn't meet their burden of proof. And for me, that's twofold. They didn't meet it because they weren't going to meet it, because I had planned on nullifying it. So it was an impossible burden to meet. Or secondly, that the defendant's narrative of how the events took place is possible, merely possible, and therefore I can acquit.
I'll just mention about burdens of proof. Depending on what kind of case it is, there are different levels of proof that the prosecution technically, although not always in practice, is supposed to overcome in order to create a condition. I shouldn't say prosecution, because in civil cases, it would be the plaintiff. But in civil cases, it's, help me out here, Catherine.
Preponderance.
Oh, there we go. There we go. And that's been described as more likely than not, or 50% plus any tiny little iota over that meets that burden. There is, in jury instructions in criminal trials, you will often be told that there in the standard of beyond a reasonable doubt does not mean beyond all doubt. So I think of that as 100%. So there is a huge range between 50% plus 0.000001 and 100%. And that whole range to me is where reasonable doubt lives. So I feel like you have a lot of opportunity to interpret that in the way that you feel is most appropriate. And I've actually seen cases where jurors will ask the judge, what does reasonable doubt mean? And they are usually very vague about it, because cases will get overturned if they get specific and it's considered, oh, you're encroaching in and lowering the standard. So that is meant to be a very high standard. So feel free to use that to do justice as you see fit.
May I add something, Kirsten?
Absolutely.
One of the most effective defenses that I've seen in a criminal case was a visual chart, and it was a bar chart. It had two lines, two vertical lines, and it said burden of proof, and it said defendant, and it had like a little bar like this big, and it had prosecutor, and it had this huge tall bar, and it gave the jury a visual, like, oh, wait a minute, this is not some, oh, I believe you a little bit more than I believe you situation. It gave them a visual idea of how steep that burden actually truly should be. I'm not going to say it is, because I don't think that it is personally,
Right.
but that
right.
it should be. And that is also where I got the possibility, the argument about, is the defendant's story possible? Because that defense attorney in their closing arguments made that statement and said, is what my client said possible? And I was surprised that the judge didn't shut that down personally, but they didn't, and he got away with it. And the defendant was acquitted. So I was like, okay, this is a good strategy. And I wish that more criminal defense attorneys would actually, even if you throw it in your closing arguments, because you're not going to be able to get it in the jury instructions or anything like that, because most of these judges are former prosecutors. So the only way you can kind of sneak it in is by using that visual chart, because it's kind of nebulous a little bit, right? But it's visual, and then people get the idea, and then
Yeah.
they throw it in your closing arguments.
Yeah. Linda says there's a church book group that just read Crook County, recommended for an inside look at the justice system. I am definitely going to make a note of that and look that up. Thank you for sharing that. Well, I guess I don't see any more questions. Do I see any hands raised? I guess if it's okay with you, Catherine, I'll just make my final my final couple comments
Okay.
as we look for a couple more questions if we have any. I just want to say that I don't believe that the American jury system is the perfect system. But I do think it's something that we still have to a small degree right now. It is really kind of on the verge of extinction, particularly after this pandemic year in which trials by jury have been essentially stopped nationwide for about a year. So I don't think that this is like the end all and be all of reform, or maybe it's not even reform itself, but it's a tool we have. And it's something that if I have the opportunity, I'm going to use that tool, even if it's not, I might be like pounding a nail in with the back of a screwdriver, but if that's what I've got, that's what I'm going to do. So I hope that this gives each of you one more tool in your toolbox if you didn't have it before, or if it was already something in your toolbox, which many of you may have already heard about it, that it's something that you see some more possibilities for how to use. And I think that's kind of the big takeaway that I would like people to have, is just, here's one more tool I've got, and if I have an opportunity, am I going to use it?
Yeah, I think I would add to that, that although this system is imperfect, it is one that is it's worth trying to save. I listened yesterday to a status hearing in which the defendant, it was the deadline for her to accept a plea. And the judge was basically trying to railroad her into taking the plea, as was the prosecutor, as was her attorney, because the system basically is not set up to do trials anymore. It's set up to bureaucratically process people from arrest through the plea process into a prison. And the judge was telling her that basically, if you go to trial, you will lose. He claimed, and I don't know if it's true or not, but he claimed, oh, we only have 1 or 2 acquittals a year, which is mind-blowing. But one of the things to keep in mind is that if people start insisting on trials, then the system is going to be in big trouble, because it's basically set itself up so that these are just, I mean, relics of a bygone age. So, and it's very hard for an individual to risk going to trial, because as long as there are few people doing it, then the system can muster all of its resources to crush that person as a example to others. But that makes it all the more important that people who are broad-minded, that have thought about these things, that are aware of nullification, get on juries, so that we can start turning this Queen Mary and get the system out of this death grip that the prosecutors have on it now, until we can come up with something better. So I guess that's kind of my pitch, which I think Kirsten has said as well, which is friends, neighbors, relatives, coworkers, whatever it happens to be, when they roll their eyes and groan and say, I've got this stupid jury summons, how am I going to get out of it? To beg and plead with them to actually go through with it, because the people that don't want to be on juries, particularly those because they don't want to, be implicated with a system that is so harmful, those are exactly the people that we need on juries. So yeah, we're deep in a hole, and we are looking to you to help us start digging out.
And with that, we're going to turn this over next back to Naomi for a debrief and closing remarks. But before I do that, I will mention that after this workshop, you will get an email with a PDF file of some resources that we are working on. And this is on me. Didn't quite get it all together, but it will have some legal terminology and other sort of resources just to kind of help you process this as you go on and think about it more. And with that, let's turn it over to Reverend Naomi.
Thank you so much, everybody. I just want to check in. There's no video, right? I just want to confirm. Somebody, anybody, no video. Okay. So
I'm sorry. Yes, no video. I was like, we can see you. I'm sorry. Okay, I'm following you. Yes, no, it's all
That's
you.
okay. That's okay. So I just want to give us some space to say a final word about what we've experienced and learned here today. I've been sort of writing down the big ideas that have come forward through our conversation. We talked about this notion of neutrality, this notion of objectivity, and to what degree is it possible for a human being to be either. And the degree to which neutrality and truth are in conflict with each other sometimes. We talked about how we have to discern our own formation related to oath taking and vow taking. What have we absorbed in our faith communities? What have we absorbed in the culture related to how committed we should be to making good on the oaths we take? Whether we should take oaths at all. To what do we pledge our allegiance? And what's the connection between pledging allegiance to the state and pledging allegiance to one's own moral compass? We talked about the conflicts and contradictions perhaps between civic duty and moral duty, that not all laws are moral, not all laws are just. And the reality of that, the truth of that, surely animates this conversation about conscientious acquittals. We talked about respectability, which again is grounded and rooted in white supremacy, that pressures some folks to demonstrate a particular kind of piety in the jury box, in the jury room, right? That piety may violate their own conscience. but there still might be a pressure to, demonstrate a kind of heaviness or a punitive posture due to what white supremacy has convinced us around respectability. We talked about ways of knowing and being that are outside the letter of the law, that are outside what I would call tyranny of the Constitution. So, how do we know what is right and what is just and what is appropriate and acceptable? Well, we learn that stuff outside of the Constitution, because in fact, we know the Constitution itself is not a morally perfect document. And so we dreamed of a world where these different ways of knowing and being would be validated and actually prioritized in our legal system. I thought a really provocative question that was raised was, if the system itself is built on myths and lies, then is it not appropriate for us to kind of respond in kind? If you're gonna lie to me, I'm gonna lie to you right back, right? So we talked about the moral and ethical conundrums of lying, or at least being silent or withdrawing from articulation of truth when is what is advantageous to save a person's life. We talked about all of this as life-saving work, right? That to preserve a person's ability to live, both breathing in and out living, but also living free, is a holy act. And then maybe the last thing I would say is that we dreamed of a world where there will be alternative mechanisms in our communities that can hold people accountable and repair harm in community without human beings ever being required to sign on the dotted line to consent to another person's death. We dreamed of a world where that is no longer the case. And that's not the world we have right now, but perhaps that's the world we can call into being. So I want to leave a few moments for you to put in the chat maybe one thing that's in your suitcase as you're walking away from this teaching. What's an idea, a question, a concept, a task that is top of mind for you as you are leaving this space? And we'll pause and give people a moment to respond. You can go ahead and put it in the chat. Here, Reverend Dr. Nakia is saying, how do we educate our congregations and Black service organizations and communities on jury nullification as part of the collective effort toward abolition, right? I certainly didn't know about this until I knew about it, right? And that was like 5 minutes ago, not 5 minutes ago, but, people probably don't know that they have this right as a juror. So how do we educate folks? Yeah. Any other thoughts, comments, questions, takeaways? Michelle says, my duty is to educate those around me, right? So now that you know, you can't unknow, right? Now that we see, we can't unsee. So yes, the duty to pass the gift on to somebody else. Yeah. Any other thoughts? Okay. Well, again, thank you all so much for this robust